Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Today's episode of Legal Tea is a cautionary tale where we talk about real-life cases of mine with real-life people, real-life clients, and real-life facts. Though, of course, names are altered for confidentiality purposes. So today's cautionary tale, we're going to be talking about a variety of real-life examples where beneficiary designations have gone wrong. Very, very wrong. But before we dive in, I feel like I need to give some general kind of basic information on what I even mean by beneficiary designations. When I say that term of art, beneficiary designations, I am not talking about, who's the beneficiary of your will or trust. Instead, I'm talking about how some assets allow you to put beneficiaries right on the asset. So you know how you can list beneficiaries on things like retirement accounts or life insurance policies, even your house in some states. Let's talk about the advantages and maybe let's call them the disadvantages of beneficiary designations. Advantages first. So beneficiary designations allow for a nice, clean way to avoid probate. Probate, the court process that gets assets from point A to point B, only governs assets that are one, in one person's name, and two, have no beneficiaries designated. Because so many individuals have beneficiaries designated on assets like retirement accounts and life insurance, those assets pass free of probate, which is great. Woohoo, right? But there are sometimes, I'm going to call them disadvantages though. And those are when you, one, fail to keep your beneficiaries updated. Two, when there is an unintentional conflict between who you list as beneficiary on the asset versus who you list as beneficiary in your will or trust. And three, your beneficiaries have things going on in their life that maybe you don't want them to freely inherit. So more on all of these here in a second. Today's cautionary tale episode is about these three things that I just listed. And the cautionary tales are going to be real life examples where I've seen things take a sharp left turn. And we're going to tackle them one by one and in the order I just listed them in. So first, we're going to talk about failing to keep beneficiary designations updated. So one of the classic cautionary tales that I share with clients all the time in regards to this topic is one I worked on a handful of years ago. So here we go. A gentleman passed away. And his sister was the estate representative, so the executor, the personal representative. It was a fairly straightforward case at the beginning. And if I remember correctly, I think he had a house, a few small bank accounts, and some personal property. Because the value of everything, though, we did have to open a probate estate. And things were going well. We were smooth sailing. Then one day, I got a call from the sister, and I thought it was just going to be like a, hey, where are things now? How are things going? Sort of conversation. No. I often tell estate representatives to forward the deceased person's mail to them because that is one way to ensure bills are being taken care of. And sometimes we actually find out about assets that maybe we did not know existed. So I hopped on the phone when she called, and she proceeds to tell me she received a statement in the mail for a retirement account, and she wasn't really sure what she was supposed to do with it. Well, as you likely know, retirement accounts often have beneficiary designations on file on the account. So I told the sister, okay, well, we need to find out if there's a beneficiary on the account, so give the financial institution a call and check on that for me. And when you have that information, give me a call back. back in my early days, I wasn't as cynical as I am now. So at that time, I didn't really think too much about it, to be honest. I just kind of hung up and moved on. A few hours later, I got a call from the sister and she says, "Hi, Jenny. I called the company and they said Susie Smith," obviously a fake name, "they said Susie Smith is on the retirement account as a beneficiary. Susie was his ex-wife, Jenny, so won't the will just override that and the funds just go to his kids?" I immediately paused, collected my thoughts, and calmly replied, "I'm so sorry to be the bearer of bad news, but the beneficiary designation trumps the will, so that account is going to Susie." Yeah, that wasn't a fun thing to deliver. Thankfully, the account was only like $15,000 or something fairly minimal. But hey, a chunk of change nonetheless. Heck, I take a free $15,000. So the sister proceeded to inquire about the how and the why. I unfortunately had to explain that we're left with what her brother left. And we can't just assume that her brother did not want those funds to go to his ex-wife, Susie. Maybe they were amicable, maybe they weren't. Nonetheless, in my little estate world, assuming is a no-no. We cannot just make up things to benefit ourselves. That could get her, the sister, in trouble as the estate representative, and heck, even me in trouble. So yeah, friends, check those beneficiary designations. Keep them updated. I've seen accounts and assets go to ex-spouses, ex-partners, parents over children, etc. So let this cautionary tale be a lesson for you. Okay, moving on to the second topic, which is the unintentional conflict between the beneficiary designation and the estate planning document. So, of course, this is along the same lines as that prior cautionary tale I just shared. But I just have to kind of bring home that if there's a conflict between a beneficiary designation and the estate plan document, the beneficiary designation wins. You know, all too often do I uncover people that think that doing estate planning, like a will or trust, etc., allows them to sort of throw on their superhero cape, and that just, doing that document supposedly cleans up all their assets and accounts. And this conversation often comes up when I first meet with a prospect or a client. And when I'm going over what all these estate planning documents are and what they do and when they activate, it's just a very natural segue when I bring up talking about a will or a trust, because it's critical that you get your assets to play nice with your will or trust. So here's our second cautionary tale for this episode. A couple years back, I tragically worked on a case that involved someone that passed away that was young, in their early 40s, and she was a single mom to 2 awesome kids, and awesomely, good girl, had done a will in case something were to happen to her. Her biggest asset was a life insurance policy. She rented, so she didn't own a house. She had a pretty small bank account. So her total estate value did not rise to the level of needing probate because the life insurance had beneficiary designations on there. So I was meeting, which I'll get to in a second. So I was meeting with her mom about what to do following her daughter's passing. And it was, of course, a very heartbreaking meeting, to say the least. And by the end of the meeting, somehow it got even more heartbreaking. So I was talking to her mom about each asset one by one. When we got to the life insurance policy, she shared that it was a term life policy. So not a whole life. So there's 2 types, term life and whole life. This is a term life insurance policy. And the death benefit was $1 million. And just a quick side note, term life insurance policies, even ones for like the death benefit being $1 million, are actually fairly affordable. So anyway, I inquired about its beneficiary designation. And she said, for some reason, she has me and her dad on there as 50-50 beneficiary, equal beneficiaries and not the kids on there. But yet her will, of course, left everything to her children. So yet again, I get to be the bearer of bad news, and I share that the life insurance policy is going to her and the girls' dad, and not through the will, which would go to the kids. And that's when she laid it on me. Oh my gosh, Jenny, her dad is totally estranged, and they had not talked, nor did they have any relationship for like 10 plus years. And guess what happened? The girl's mom got her 50% and handed it right over to the girls' kids. The dad? Well, he definitely claimed his 50%, and after multiple attempts to contact him, he never replied and pocketed his 50%, which was $500,000, meaning he didn't share it with her kids, which were his grandchildren, technically speaking. But again, there was no relationship there. Wow, right? I still think about this situation often, and it just makes my stomach flip every single time. All right, on to our last topic, which is the unintentional effect or unintentional outcome on beneficiaries. So what do I mean by this, you ask? Well, I always say that in my little estate and elder law world, if it sounds too good to be true, it very likely is. Most things in my world may sound awesome, but there may be a little catch. So here's a perfect example of what I mean. So often, people get hyper-focused on ensuring beneficiaries are designated on assets and accounts that they fail to take kind of a 50,000-foot overview of what the literal outcome of all of this is. And I mostly see it with financial advisors, honestly, and not to pick on them in all seriousness, but how and why would they know the legal effect of some things? They're not attorneys after all, so I really truly am not picking on them. But there's a whole lot of people that will put in the time and effort to make sure beneficiaries are designated on assets for the sole purpose of ensuring probate is avoided, which, hey, that is wonderful. However, what did I just say a second ago? If it sounds too good to be true, it probably is. Well, that applies here. And I'm really looking at you folks that have minor kids or minor beneficiaries, like under 18. Special needs kids or beneficiaries, or even beneficiaries that have stuff going on in their life. So think like addictions, divorce, creditor issues, bankruptcy, etc. If they inherit outright through a beneficiary designation, that means, one, those minor kids and beneficiaries get their hands on the full shebang come 18 years old. I know what I would have done with money at 18 years old. Two, those special needs kiddos and beneficiaries, they may lose their governmental benefits like Medicaid. And three, those beneficiaries that have stuff going on, receiving money outright could fuel their addiction. The money could get tossed into the divorce proceeding or creditor proceeding or bankruptcy proceeding. All of this is very yikes, right? There are ways to protect your beneficiaries from this happening and avoid probate, but it's likely going to involve, one, a thorough conversation with an estate planning attorney, and two, more estate planning than maybe you originally thought you needed. So something maybe like a testamentary trust or a living trust. One of my favorite things, or maybe lack thereof, least favorite things, I hear all the time from prospects and friends and family members, clients, is, Jenny, I just need a real simple will. Nothing fancy, just really simple. Well, I hate to burst your bubble, but there's no such thing. Can a general practice attorney throw one together for you? Sure thing. Will some attorneys agree to put together a real simple will for you? Yep. But if you choose to go down that path, remember this episode. Remember these cautionary tales, and perhaps reconsider who you're working with. They just may not be skilled in this estate planning conversation and may be doing you a disservice, not maliciously. They just don't know what they don't know. Alrighty, I'll get off that soapbox now and we'll wrap up this episode. Next week, we are back to the current events, current trends topic. Something I've seen or run across that I think would be interesting on here to chat about. So during that episode, we're actually going to be talking about a recent article I stumbled upon that I thought was fascinating regarding unclaimed property. And it's really interesting. So tune in next time. Until then, Legal Tea listeners, be well and talk soon.